Commerce, Kampala Arcade Traders Association, Kampala City Traders Association, Uganda Small Scale Industries Association, Uganda National Traders Association, the Gen Z Business Owners Association, Innovation Village, the startup ecosystem, and the independent private sector consultants. We did not stop there. We entertained financial, insurance, economic sector actors. These include the sector-specific institutional stakeholders that include Uganda Bankers Association, supervised financial institutions like banks, mobile money operators, via sector submissions. We also entertained Payment Service Providers Association. We also entertained Uganda Forex Bureau and Money Remittances Association. They too appeared and gave their views. We also considered digital, telecom, media actors in communication, broadcasting, and digital economy, include communication sector operators, National Association of Broadcasters, media practitioners, journalists, and journalism practitioners. We also entertained the civil society and non-government organizations, both domestic and international civic actors that include Anti-Corruption Coalition of Uganda, Foundation for Human Rights Initiative, Legal Aid Service Providers Association, the Rotary Uganda, Women Pro Bono Initiative, Country Directors of International Network, and various national NGOs also submitted. We also entertained international organizations and development actors under these multinational organizations and international cooperation actors. These include United Nations Country Team, international NGO community, collectively represented. We did not stop there, Right Honorable Speaker and Honorable colleagues. We entertained the labor, religious, and social institutions that include NOTU, that include Interreligious Council of Uganda, that include Muslim Organizations Coalition, and other faith-based organizations. We entertained health, scientific community, and public health research institutions, e.g., Uganda Medical Association, Uganda Virus Research Institute, Peoples Living with HIV advocacy groups. We also entertained education and academic sector that include Makerere University Academic Staff Association, universities and academic researchers, student groups, and members of the Guild also submitted. National Union of Disabled Persons of Uganda, Uganda Lawyers Voice on Climate Change, Gender Rights and Advocacy, Climate Advocacy groups. We also entertained diaspora, transnational communities, Ugandan actors, the Global Forum. This is an organization that groups all Ugandans in the diaspora. The Cheyo Association, NUP, NUP Diaspora Chapter, individual diaspora submissions. We went further and entertained professional and individual submissions. These are unaffiliated and cross-cutting. Independent consultants, individual citizens, business professionals, researchers. Right Honorable Speaker, we consulted documents. Consequently, the committee recommendations reflect a balanced synthesis of stakeholder perspectives in the key findings and salient observations. Right Honorable Speaker, permit me to present key findings and salient observations on the Sovereignty Protection Bill of 2026. Introductory consideration, looking at the scope and interpretation of Clause 2. Before presenting its findings, the committee found it prudent to clarify the key interpretive issue of Clause 2, which is application of the bill. Clause 2 sits at the core of the legislative framework, and it defines the reach of the law and it determines who is regulated and what circumstances and for what conduct. The committee reviewed the Honorable Attorney General's comments, noting that Clause 2 limits the bill to specific activities tied to foreign influence. According to the learned Attorney General interpretation, the bill does not apply to a person generally, to all persons generally, that it applies only to persons acting as agents of foreign actors, and that even then, only where such a person is engaged in specific conduct, including influencing government policy, political processes, or public decision-making for the interest of foreigners. The Attorney General clarified that Clause 2 is meant to limit the bill, not to expand it. He guided that it applies only to agents of foreign actors and only when they engage in specific influence-related activities, e.g. affecting government policies or public decision-making. In addition, the learned Attorney General noted that the bill is activity-based, not identity-based. So ordinary transactions like remittances, businesses, family support are excluded unless tied to regulated influence. On this reading, the bill presented a targeted regulatory instrument aimed at structured foreign influence operations rather than legitimate international engagement. However, the committee observes that this interpretation, while persuasive as a matter of policy intent, is not shared by the majority of stakeholders. There is a gap between the AG's intended narrow scope and how the bill is actually drafted. When Clause 2 is read together with broad definitions in Clause 1 and the expansive list of activities, including concepts such as influencing public opinion and activities that the minister may prescribe, stakeholders interpreted the bill as having a much wider practical effect. The East African Law Society, for example, in their submission, warned that the term agent of a foreigner in Clause 2 could apply to regular economic, professional, and family connections, such as employees of foreign businesses, traders, and those receiving support from relatives abroad. The Law Development Center noted that Clause 2 does not distinguish harmful actions from lawful ones. So the people could be held liable simply because of their associations, not because they caused any actual harm. This divergence, Right Honorable Speaker and Honorable colleagues, reveals a fundamental issue. The intended limitations of Clause 2 are not sufficiently clear on the face of the law, creating uncertainty as to the boundary between harmful foreign influence and legitimate activity. While the Attorney General maintains that Clause 2 limits application to specific regulated activities, stakeholders consistently note that this limitation is not clearly reflected in drafting. Therefore, the committee found that the line between harmful foreign interference and legitimate activities is unclear. Clause 2 is meant as a safeguard, but not effectively to limit the bill. This gap policy and the law shapes all the committee's subsequent findings. 5.2, understanding sovereignty. We looked at what the 1995 Constitution says versus what the bill proposes. Sovereignty under the 1995 Constitution as amended. This committee discussed sovereignty referencing the Constitution of the Republic of Uganda, herein refers to as the Constitution. The committee found that the 95 Constitution determines the sovereignty, that sovereignty belongs to the people of Uganda and not government. Specifically, Article 1, which states that all power belongs to the people who shall exercise their sovereignty in accordance with the Constitution. Article 1.2 adds that without limiting the effect of Clause 1 of this article, all authority in the state emanates from the people of Uganda, and the people shall be governed through their will and consent. These provisions establish that the people are the original source of political authority, while government merely exercises power as a trustee on their behalf. This position is reinforced by the preamble, which recognizes that the Constitution was adopted by the people in the exercise of their sovereign and inalienable right. Accordingly, the committee concludes that the state does not own sovereignty, but holds and exercises it in trust for the people. Sovereignty is actively exercised through democratic processes such as elections and referenda, Article 1.4, and safeguarded through the duty imposed on the citizens under Article 3 to defend the Constitution. So then we looked at sovereignty in the protection of the Sovereignty Bill 2026. The committee further notes that sovereignty has two dimensions. A popular one, where power ultimately rests with the people, and security dimension, where the state exercises authority to safeguard national interest. We looked at a leading jurist, Justice Oliver Wendell Holmes, Jr., 1841-1932, a renowned American jurist who served as a Supreme Court judge, who described sovereignty in similar terms. Justice Wendell Holmes perceives sovereignty as the ultimate practical power of the state to govern and maintain order grounded in the historic and social necessity for societal existence and survival. The state action is therefore legitimate only when it maintains grounded in popular sovereignty. Guided by this understanding, Honorable Speaker and Honorable colleagues, the committee observed that the bill introduces a strong emphasis on shielding Uganda from foreign influence and expands the state's regulatory powers over political and civic activity. Summarily, the bill aims to protect the sovereignty of the people, prevent foreign interference on governance, and the key features include restricting activities that promote foreign interests, which can be gotten from Clause 5, restricting non-state actors from performing government functions, which is Clause 6, criminalizing interference in elections and government operations, which is Clause 1 to 13, and regulating foreign funding and civil society activities, and restricting interference.
Is it 1 or 11 to 13?
11, I beg your pardon. 11 to 13. Restricting interference of government policy. The committee, therefore, found that the Constitution grants ultimate authority to the people, with the government acting as a trustee. The Protection of Sovereignty Bill 2026 regards the state as primary guardian of sovereignty and adopts a cautious approach to foreign linked actors. Whereas the Constitution vests sovereignty in the people of Uganda, the bill focuses on the protection of sovereignty through state action, reframing sovereignty in the security terms and promoting stricter regulation of foreign influence. We looked at broad definitions and the scope. The committee found that the bill definition of foreigner and the agent of a foreigner are overly broad. And as defined in the bill, it wrongly includes Ugandans living abroad. It wrongly includes students. It wrongly includes researchers. It wrongly includes professionals working in international partners. It wrongly includes government ministries, departments and agencies exercising regulatory authority under any act of parliament, and organizations and companies that simply have foreign investors or cross-border businesses. Instead of targeting harmful foreign interference, the bill inadvertently ends up covering normal economic, academic, and community activities. This, Right Honorable Speaker and Honorable colleagues, blurs the line between harmful foreign interference and ordinary lawful activities. It making everyday economic, academic, and civic engagements legally risky. Clause 1 and 2 are specifically powerful in determining who is regulated and punished, and even raising constitutional questions about citizenship by classifying Ugandans abroad as foreigners. Stakeholders warned that this could criminalize normal cooperation, such as research, education, and diaspora support. In fact, the Law Development Center has termed it as regulatory contamination, where indirect foreign links extend liability across entire economic and social chains. The committee therefore recommends, 1, that to restore legal precision, to ensure proportionality, and to align the bill with constitutional principles and practical realities, the committee recommends the following. Amend the definition of a foreigner to limit it to non-citizens and foreign registered companies. Amend the definition of agent of a foreigner to only include people who formally and knowingly act on behalf of a foreigner to influence public policy, elections, or national security. Insert new definitions of words and phrases used in the bill to improve clarity. Insert an intent requirement, which the land colleagues call mens rea, so liability only arises with deliberate influence. 5, insert a clause explicitly protecting legitimate economic, academic, humanitarian, developmental, and civic activities to prevent misinterpretation and ensure lawful activities are not captured by the bill. 5.4, creation of a parallel regulatory regime. The committee observed that the bill creates a new approval and monitoring system under the Ministry of Internal Affairs. However, many sectors in Uganda are already tightly supervised by strong regulators, these include Bank of Uganda, Financial Intelligence Authority, the Uganda Communications Commission, Insurance Regulatory Authority, and university councils. Stakeholders argued that the bill repeats work already done by these regulators and may create conflicting rules instead of improving oversight. This duplication can lead to confusion about which rules apply, multiple reporting requirements, and uncertainty for businesses and institutions. For example, both telecommunications and banking sectors already operate under strict regulatory systems. Adding another regulator with similar powers could disrupt systems that are currently functioning well. The committee notes that these sectors are already governed by detailed laws and licensing frameworks. Stakeholders also warn that the bill could create a parallel system, quote unquote, run by a security-linked department that may not have technical expertise of existing regulators. Media organizations, too, pointed out that the issues such as foreign funding, transparency, external influence are already addressed under current laws, including anti-money laundering legislation and the NGO regulation. The private sector representatives highlight the economic impact of the bill, more uncertainty, more regulators to certify, and higher costs of doing business. Stakeholders caution that the bill risks creating duplication, institutional conflict, and opportunities for forum shopping. The committee recommends, therefore, that in light of these concerns, the committee recommends that all institutions and individuals already supervised by a regulator established under an act of parliament should be exempted from the bill. Concentration of executive power in the minister. The bill gives the minister responsible for internal affairs wide and layered powers. These include authority to 1, define the key terms used in the law, 2, approve or reject the foreign funding, 3, register or cancel organizations, and determine how the law will operate through regulations. The committee notes that while each of these powers may be common in isolation, their combination in a single office creates a system where participation in economic, civic, or institutional activities depends heavily on the minister's approval. This raises a deeper constitutional concern, not just about administrative efficiency, but about the overall design of governance. The committee elaborates these issues under 3 major themes, from regulatory oversight to discretionary control, where stakeholders observed that the minister's power and the role goes beyond implementing the law. The minister effectively controls access to the law itself, and the minister can decide who falls under the law, who controls access to funding, grant or withdraw legal status, and shape how the law functions in practice. This, we noted, it risks turning the framework into permission-based system where individuals and organizations must seek approval to operate instead of following clear, predictable rules. It also has constitutional implications. This concentration of authority raises significant constitutional concerns. It weakens the separation of powers by placing too much control in one office. It reduces checks and balances from independent institutions. It increases the risk of unfair or arbitrary decisions, especially where the bill lacks clear procedures, timelines, or appeal mechanisms. A system that relies on discretion rather than clear rules undermines legal authority. No, I beg your pardon, undermines legal certainty and public trust. We also looked at reframing sovereignty. The committee notes that many legal and governance submissions view this more than an administrative matter. They see it as a shift in how sovereignty is exercised. Instead of power flowing through established institutions and the people, it risks being concentrated in one single office. From human rights perspectives, any limitation on rights must meet three tests. 1, legality, necessity, proportionality. The bill does not clearly demonstrate how these standards are satisfied. We therefore recommend, the committee recommends that to preserve the bill's objective, I beg. Can I conclude? Thank you. Let me read. Thank you, Right Honorable Speaker.
How many minutes do you want to conclude?
Yeah. I need 5 minutes and I conclude.
5 minutes. I will add the other side also 5.
Okay. The committee recommendations. To preserve the bill's objective while restoring institutional balance and constitutional compliance, the committee recommends the following amendments. 1, limit the application of the bill to honorary agents of a foreigner. Exclude the application of the bill to Ugandan citizens residing outside Uganda. Remove the power of the minister to declare any person a foreigner. Remove the restriction on recruitment and employment of a person who are abroad from disruptive activities. Provide for the elements of an offense. Avoid unnecessary bureaucracy in the implementation of the policy. Replace ministerial approvals with the declaration of funds to the relevant regulator. We looked at disruption of financial and economic systems. We also have recommendations. On that one, to safeguard national interests without disrupting financial systems, the committee recommends shifting from broad approval-based controls to a targeted risk-based approach by 1, protect everyday financial flows by exempting personal remittances, routine banking transactions, and legitimate business financing. Replace blanket approvals with disclosure requirements, reserving prior approval only for high-risk activities such as funding linked to political influence. Adopting a flexible risk-based declaration system developed with financial regulators and aligned with existing anti-money laundering frameworks. We looked at the vagueness and criminalization of risks. Right Honorable Speaker, we recommend that we align the bill with constitutional requirements of legality and certainty. The committee recommends the following amendments under vagueness and criminalization risks. The committee recommends clearly define all criminal offenses, specifying prohibited conduct and the required intent and the harm addressed. Reduce the penalty of 20 years to 10 years and a fine in the case of legal entity for 200,000 currency points to 1,000 currency points. Limit offense to conduct that limit offenses to conduct that poses a real and a demonstrable threat to national interests, avoiding broad terms that may capture lawful activities. Include measurable thresholds or criteria, such as scale or impact, to guide enforcement and reduce subjective judgment. Insert a saving clause to protect legitimate activities such as business operations, research, journalism, advocacy, and civic engagement. Introduce procedural safeguards, including enforcement guidelines, written reasons for decisions, and access to administrative or judicial review. We looked at the impact on academia, health, and innovation systems. And we recommend that the academic institutions, research bodies, health and medical facilities legally operating in Uganda be exempted from the bill. We examined the certificate of financial implications because this is a requirement of Public Finance Management Act. We looked at the cost. Right, Honorable Speaker, we interrogated it. Actually, the details are there. We concluded that, therefore, since in conclusion, Right Honorable Speaker, in conclusion, the committee undertook extensive consultations, and the views received reveal a shared concern across all submissions. There is broad agreement on 4 key points. The bill's objective is legitimate, but the definitions and applications are overly broad. The regulatory approach duplicates existing legal institutional frameworks. Excess power is concentrated in the minister, and the bill's impact could extend across the entire economy. In response to the above and the concerns, we interacted with the learned Attorney General again. And now we conclude that the committee, therefore, recommends that the bill proceed to second reading, subject to proposed amendments attached thereto, and any further improvements this August House may consider appropriate.
Honorable.
Right, Honorable Speaker.
I want this part where you interacted with the Governor of Bank of Uganda. Read.
Okay. In response to the concerns, the Attorney General proposed the areas for review which were supported by the Bank of Uganda. The committee has carefully considered these proposals. We have also incorporated these amendments where applicable in the bill. I want to report that, yes, we interacted with the Governor Bank of Uganda actually twice. After we had gotten proposals, we flashed to him, and the Governor Bank of Uganda also agreed with the committee and sent us more amendments, which we incorporated.
Thank you.
I need to report.
Thank you.
I need to report, however, that this majority report that was signed by more than 3/4 membership also has minority reports. In fact, because it's my duty as the reader of the majority report to report the House that we have 5 minority reports. 5 minority reports.
Are they 5?
I beg to report, Right Honorable Speaker.
Thank you. Can I have now the minority report? Thank you. Thank you. Thank you.
Right Honorable Speaker, I present this minority report, and we have agreed with our colleagues who also dissented that this will be the order of presentation. I will present first, followed by Honorable Wilfred Niwagaba, to be followed by Honorable Gilbert Olanya, to be followed by Honorable Abdallah Kiwanuka, to be followed by Honorable Betty Namboze, and lastly, the Honorable Medad Segona Lubega. And we have
and the rules of the time still apply.
Before I begin to present, if you may allow, I can address you on that. When a member of a committee dissents singularly, the weight of the report demands that we be accorded the same time frame, Madam Speaker.
Which rule is that? Which rule is that?
Under Rule 215, Sub-Rule 3, it says that a member dissenting or members. And the reasons are in this report, Madam Speaker, you'll see. If I may address you briefly, in the committee...
I am giving you 35 minutes.
This is a...
All of you. Honorable members, before we continue, we have Honorable Tim Bernard from Maruzi. Welcome, Honorable Tim. And then Honorable Tibiase Peace from Jinja. Welcome. And here, join me in welcoming our new members. Yes.
This is a minority report, Madam Speaker, in substantial dissent of the majority report of the Committee of Defense and Internal Affairs.
Honorable members, can we listen to the report?
Guys, musobola okukiraba nti bano abasajja ebyamateeka tegabiriko. Ekikazi kino kimulaba ekyambadde ogukutiya gwe gundi ku mutwe. Kibuuziza honorable nti teeka ki n'akikootingire etteeka. Nejagala kutegeeza nti bano abantu tebali ku byamateeka. Kino nze kinjagala era ekinteesezaako stream eno ba streaming ekiri mu parliament mutegeere bannayuganda nti bano abasajja tebali ku mateeka gaffe. Ebyaffe bye tuliko si bye baliko. Bebya bibaliko birala nnyo si mateeka. Omukazi bamusomedde etteeka. Speak of the house. Ne bakootingira etteeka ne bakulaga n'akatundu mweriri n'aganze nze ekyo nkiganye nze ngambye 35 minutes. Kati ekyo kakitulage bannange kye twetaaga bannayuganda kusitukira mu abampuliza ku mikutu gyaffe gyonna gya APO media yonna gye muli. Mbasaba ekintu kimu. Ono ina nonsense bino bye mulaba ku ma TV. It's just a nonsense that we are showing you. Tewaliwo kye bigenda kuyamba. Kye twetaaga okukola yenze naawe kusituka ne tugoba n'abasajja ali tubasobola. Twetaaga olunaku lumu ne tusitukayo miliyoni emu n'olaba kino ki parliament ne tukikumako omuliro. Ne tukumako eno parliament omwe tujja kuzimberera kubanga eno yaliwo ku mulembe gwa Amini yadda ku mulembe gwa Bobote yadda olide Museveni tena tujja byokya bino tuzimbe ebira bire parliament bino byetaaga kukumako omuliro bino n'ababirimu bonna beetaaga kwokya. What is this nonsense? That which article is that? Oh, musajja akusomedde etteeka naye n'omuga no ngambye like constitution bagiye kwasa bwekwasa bo batunyigirize bakole bye baagala ffe tusasulire bakole ebikolobero ffe tusasulire. It is my humble request, Ugandans. I know you are so many following and listening to me. Facebook, TikTok, YouTube, X, all over you are watching me from. Njagala kubasaba twekolemu omulimu guno guyumba gwetaaga kwokya bana abantu betaaga. We must stop this nonsense. Batukozesa bukozesa ffe tugenda osasula amabanja ge bageri mu kuyisa ebyowulira byemulaba byonna byembatereddeko wano. Bali mu kuyisa amateeka sente tugenda kwongera bweziti ffe tugenda zisasula ate bagenda na kwewola ffe tusasule. Naye zino embizimbu bye zibikola mu linnya lyaffe. Imagine mbu ffe twabironze bikole ono nonsense. Mwe mbatereho kasasiro ono mumuwulirize, but I want you to get ready my dears. Get ready sawa yonna bino bya parliament. Ulira ekiri wano ulira Ulira Chief Parliament.
Right Honorable Speaker, I am well conversant with the rules of procedure of this House. That's why I've confined myself to this report. I will be available to clarify if necessary. Members can listen, I will respond to you. Thank you.
They cannot allow him to act. The guy is quoting the law, is telling them according to the law, they don't listen, including the speaker. Listen the nonsense that is here.
Speech above for the purpose of reminding ourselves as legislators
Can I
fellow
have a chance to have a
Ugandans.
copy? Can I have a copy?
Owulira. Gulwabako kyayogera nga gu speaker guvaayo nga gwasaba.
No, don't. Me am analog.
Kugamba bitukozesa bukozesa bino bifala. Zino mbizi zennyini wamu.
And fellow Ugandans, for we have come from the far, we have come, and the apparent U-turns and reversals that are being made for whatever reasons being advanced, which reasons have no place in shaping the sovereignty of the people of Uganda. Areas of dissent and statement of reasons for dissent. Area 3.1, violations of the rules of procedure of Parliament. Madam Speaker, during the consideration of the Protection of Sovereignty Bill 2026, the co-chairpersons violated several provisions of the rules of procedure of Parliament of Uganda. Rule 135 of the rules of procedure is instructive on reference of a bill to the committee as follows. Sub-rule 1, whenever the bill is read for the first time in the House, the bill shall be referred to the appropriate committee appointed under these rules. Sub-rule 2, the committee shall examine the bill in detail and make all such inquiries in relation to the bill as the committee considers expedient or necessary, and report to the House within 45 days from the date the bill is referred. 3, except in the cases of very minor amendments and subject to Rule 138, all proposed amendments to a bill referred to the committee shall be presented to the committee by the person proposing the amendment, and the committee shall scrutinize the amendment together with the bill. 4, the committee may propose and accept proposed amendments in the bill as the committee considers necessary, if the amendments, including new clauses and new schedule, are relevant to the bill. The minority observes that the committee violated sub-rules 2 and 3 in as far as it did not examine the bill in detail and further did not make all such inquiries in relation to the bill. In the view of the minority, the decision of the committee through a vote on a motion by Honorable Fox, Odoi, Oyelowo for an omnibus adoption of all clauses of the bill and the amendment by the learned Attorney General without examination and inquiry violated Rule 135. The minority, Madam Speaker, also observed that the Protection of Sovereignty Bill 2026 was proposed by the Minister of Internal Affairs, Major General retired Kahinda Otafire. Sub-Rule 3 restricts the latitude to propose substantial amendment to only the mover of the bill, which is the Minister of Internal Affairs. Only minor amendments may be proposed by any other person who is not the proposer to the bill. With all due respect, the learned Attorney General proposed 18 amendments, all quite substantial in nature, which amendments the majority unilaterally adopted and relied on to pass the bill in the committee. The committee sought to have rejected the committee ought to have rejected the substantial amendment proposed by the learned Attorney General outrightly. To even make it worse, Madam Speaker, the new amendments were laid before the committee in form of a new bill. Rule 135, Sub-Rule 1, confines the committee to a bill read for the first time in the House and referred to the committee. The committee is stopped from directly receiving bills not read in the House and referred to it by fraudulently bypassing this House and smuggling an amended version of the bill to the committee, an illegality that goes to the root of parliamentary procedure and practice was committed and cannot be cured by any explanation at all. Madam Speaker, the minority further observes that no sooner had the learned Attorney General purported to present the amended Protection of Sovereignty Bill 2026 to the committee at about 12 noon on Thursday, 30th April 2026, than His Excellency the President, through his address to Ugandans at about 4 p.m. on the same day, withdrew instructions from the learned Attorney General. Instead, President publicly assigned Honorable Dennis Amson Obua to ensure that the bill concentrates on what he calls sovereignty of policy decision making. In the practice of law, there is nothing professional as humiliating as a client withdrawing instructions from you and sharing it out with the public outright. No wonder, since then, neither the Attorney General nor the Minister of Internal Affairs ever attempted to appear before the committee or the House. The House must therefore not entertain the two on anything to do with the Protection of Sovereignty Bill 2026, since the President withdrew the vote of confidence in them. The minority, Madam Speaker, formed the view that Honorable Obua Hamson, having been given fresh instructions as per the written expression of the President, ought to have immediately sought audience with the committee to present the instructions given to him. Was it an instruction to withdraw the bill, or what was it? Despite the insistence of the minority to invite the Honorable Hamson Obua under Rule 135 Sub-Rule 2 to make all such inquiries in relation to the bill, as this was the most expedient, the co-chairpersons, Honorable Kajwenje Wilson.
Honorable Jana, sorry for interruption. My presumption is that when you bring a minority, you bring your points of departure, not procedure. Flavia, points of departure, not a debate on the procedural
ways. Buli wekimulaba nga alina byayogera nga bya makulu nga kimu interruptinga tekyagala ayogere kwegamba byo birina waddoze mu parliament. They are always having their own program, and in case oba otandika obaleetera ebintu nga tebabyagala opposition kwegamba bagitegekera byerina okwogera byonna nnyonnyola nga bwe babyagala kasookyusamu gano agabizo omanyi kye gakola nga gutandika ate jjukira gwe member wa parliament gwe olina kubeera wansi wa rules ezo, naye byo tebikwatibwa mateeka kwegamba amateeka bagateerawo ffe bo tegabakwata. Nze bannayuganda mbateereddeko stream eno kubalaga tibanange parliament erina mugaso. It is we to liberate our country. It is we, the citizens. It is we.
When instead went to Honorable Bua, oh, they should have.
Thank you, Madam Speaker. The co-chairpersons were evident. Madam Speaker, this is important. The co-chairpersons, Honorable Kajwenje Wilson and Honorable Baka Mugabe Stephen, were evidently partial, hostile, and continuously switched off the microphone of members in the committee they perceived to be against the bill. Contrary to the established practices of availing physical copies of submissions of stakeholders to members of parliament at the retreat, members of parliament were instead told to physically get copies to members of parliament. Instead were told that physical copies could not be availed since parliament was on a weekend. The views of Madam Speaker, views of selected stakeholders were instead sent to members on WhatsApp to read on their phones. Members who were not on WhatsApp or whose phones could not open the WhatsApp were effectively denied critical document. Madam Speaker, the privileges of a member of parliament were violated to the extent that some of the members of the committee had to jump on border to travel to Nassau Road to print the stakeholders' document for their own reference. A passionate plea for the committee to adjourn until Monday, when Parliament is open, for purpose of printing or photocopying the document was turned down. But Right Honourable Speaker, this gross.
I am rising on a point of procedure. I am rising on a point of procedure, Madam Speaker. A minority report, as per our rules, envisages that a member participates in the proceedings of a committee and then disagrees with some of the decisions taken by the majority. You read. But not to come here and tell us stories how the committee. So, no. Read the rules. This Parliament, while debating reports, is not for storytelling how members were seated, how they were reading, going on border. What we expect, Madam Speaker, from the minority report is where the member disagrees with the decisions of the majority report, not to waste time of Parliament talking as if he's just reading a story. So is the honorable friend of mine proceeding correctly by wasting our time as Parliament instead of being straight?
Honorable Dur.
Uganda bali ku stream eno mulaba ekiri mu parliament nti bo babayita mu parliament nga wena kye baagala bubeerewo obubeezi kati opposition MPs bwe babeeramu bo bayambako buyambi kulaga bazungu mbu parliament yayisizza then majority neeronda you get nembo baba balina ekyabwe kye baagala yagala gaana kati ekyandibadde kikola opposition kuvaamu butabeera mu parliament naye nabo gino emitwe nabo tebasobola vaamu kuba nabo balyayo akaseera kiri kibatwalayo but nothing else kubanga tiriwulira omusajja wawule ripooti gyawa naye tebamukkiriza because bisi bye baagala bo balina bye baagala ayogere era bye bamwagaza ne bwabivaako ne bwakola atya balina bye baagala ayogere bw'atabyogera bajja mujjako microphone olaba lusipiika bwe lwetunuza bavayo ne bakuyimiriza twagala ayogere kino ddaku kiri that is it kati nagana agasajja tugasaba always ngamba bino opposition MPs tutandikira ku Joro Senyini mutandika okukunga ffe tuli wano ku ground tusobola okukola kye tulina okukola tubasaba ekintu kimu bino bye mugenda ali ne mwasamira ku buzindalo buno nga temulinayo n'amakulu babayisanga mbwa babalagira ebyokwogera bwena mubawa ekitiibwa tebabawa ekitiibwa kubanga mwe babanyigiriza kuyita mwaga amateeka bo tegabakwata mwe gabakwata tubasaba ekintu kimu ulira
Or incompetence. By the time you come and be a member of parliament in this house, let's tone down our language. Let it be parliamentary. Even when I'm enjoying your story, at least let's be parliamentary. This gentleman.
kyokka mukazi gwe gumuba bagusomera etteeka eri mukkiriza okukola kyakola nekigamba saagala byo tobisoma olabye so banange mbasaba bannakyalo bannange tukwate bano ba MPs bafaayo ku byalo bo tubasobola genda wewakaawo mugambe buli wokwata microphone kunga abantu bajje mu kwekalakaasa buli wokwata ku microphone tukunge bw'aba tayagala bakunga naye agaba n'engwala agaba n'engwala munonyesha bimu marende gyali agaba n'engwala bwe babanga bali balina emmundu ezibakuuma bano tubasobola bano baffe bo tubeesobole bate mwali wano musaba akalunga mugenda kubeera mugenda duumira magaali nga tumanyi mugenda kuduumira bantu kukuŋŋwanya bantu naye bwe mujja nga bamaze obayisaamu amaaso kati parliament begwa bagenda fulumawo kabalaza bahaniko okweyogeza ebibaddeyo sipiika naye tebasobola ganti katugende tulwane banange bannayuganda mujje mwekalakaasa tebasobola kyogereza embaata zola naye era bwe bazijogera mu parliament puppets kati muhoozi alieri agamba
At par on the certificate of financial implication of a bill as follows. 1. Every bill introduced in Parliament shall be accompanied by a certificate of financial implications issued by the Minister. The certificate of financial implication issued under Sub-Rule 10 shall
Akati oba atona avudde wa unye onkwawa wano. Oba siteera. Ng'owunyidde wafuuka muganda wange. Oba oli musajja oba oli mukazi. Bino byenjogera by'abantu abategeera simmwe bannange. Nasenga ne Facebook naye emanya abantu amu neetabakkiriza kujja kuzirayivu zaffe n'emikutu egimu. Njogera n'abategeera. Njogera n'abategeera bwana Roni.
Finance, Planning and Economic Development, signed by Amos
Kava mu kyalo tomanyi ensi bw'etambula twogera oyogera anayi.
The Honorable Lugolobi states as follows: the proposed bill is expected to strengthen Uganda's policy autonomy and national security architecture, improve coherence in the management of foreign aid and foreign funded activities, and support stability in governance and public order. These outcomes are expected to contribute to a more secure environment and implementation of government programs and long-term national development. The minority draws the attention of honorable members to the sad realities that has befallen this country, that the entire ministry responsible for finance, planning and economic development does not know what constitutes an economy of a country called Uganda, and therefore are unable to articulate the impact of the bill to the economy of Uganda. The minority observes that instead of assessing the impact of the bill against well-known parameters such as GDP, sovereign debt, debt to GDP ratio, balance of payments, central bank reserves, interest rates, inflation, exchange rates, rate of growth, etc. Alien parameters form the basis of the assessment. The observation by the majority report that the certificate of financial implication met the statutory standard.
Honourable members.
Let me just put on record.
Yes.
This minority, which I wrote, is actually.
Let's capture all the all what has been in all the minorities.
This is what exactly
so
happened
how much,
in the committee.
let me give you 2 minutes. Let's give you 2 minutes.
This report I have is 40 pages.
Let me give you 3 minutes to summarize.
And in the committee, the same treatment, Madam Speaker. To the House.
I have actually given you the same amount of time. 2 minutes. You conclude.
Government ya Museveni ebeefunye ka debate nti twa debate nze ne opposition yabaddemu then ne kiyita mu mateeka kati kibeera legit ne bwe kibanga bo bakireeta ngera bw'okiraba ekiteeka nti kyabwe kati opposition buli weebeerayo ne bagimanyira bwe bati ne kiggweeraawo mu mateeka agasetingibwa parliament ng'omuzungu atukwasa obufuge buno emyaka 6 egiyise kibeera legit nga opposition ebaddemu ne participating nga boolaba kati bwe bakola bali mu kubavulunga babayisaamu amaaso tebalina na wadde na mulamwa naye eri mu tteeka baba tebamenye mateeka aba NRM kireeta kiba kifuuse legit mu mateeka naye bwe bafuluma ne batabeerawo tekibeerawo so mu bufunze this opposition is helping Museveni to legitimize his bad action that they are doing on us. Ebikolwa bino tebisobola kubeera legit mu mateeka kyovulaba onoonya n'omusango gw'ovunaana Museveni mu bazungu ne gukubula lwaki bw'aba yeewa obukadde obuwumbi 3 mbw'agenda bulya ne mukyala we Janet olunaku buyitira wano kati opposition neebeeramu negamba nedda tukiganye naye majority etteeka ligamba nti what the majority said You get kati majority bo bakimanyi fe tuliyo batono naye era mugendayo okuyambako etteeka eryo okubeera regiti mu mateeka kati bwe muvaayo ne mutabeerayo tebasobola biisa ne bibeera mu mateeka kyova olaba luli we baali badduseeyo ku mulembe gwa Mpuuga nga Mpuuga ayagala kwegula bamwongera obwa leader of opposition bwe yaddusa ayababaka n'abaga tufulume Museveni yabawa n'obukadde 10,000 okakasa nti bakomawo tebasobola kuyisa ebyo biteeka nga muvuddeyo ne bibeera regiti naye buli bwe mugendayo ne muparticipatinga kiba kiyise mu mateeka amatuufu era naffe bwe tulikwata obuyinza ekibiina ekiba kisinza ababaka abangi oba kale bamember of parliament abasinga obungi kasaba wanika omukono ku kintu kiba kiyise era kiba kigenze mu mateeka oba kikyamu oba kibanyigiriza nga bola bali netteeka bali tunyigiriza naye by the fact that nti opposition gye bali mu parliament era babaddeyo baparticipating ekyo kiba kigenze ki mu mateeka era liba liyise bulungi liba lisibamu ekitiibwa mu mateeka g'ensi yonna oba linyigiriza litya kubanga North Korea lirina amawanga amalala lirina mu bufunze. One of our biggest problem is our MPs nkadem. That's why President Kyagulanyi tojja musanga nga supportinga bino no gomuwulirize bw'aba ayogera oba ali omuddeho nga this is politics. He will never support politics. Always ayogera ku kye bayita revolution. Museveni tusobola mukubira mu revolution manner buli wokireeta political nga bano we bali wano habino obuzannyo bwe kati bano abazanyisa buzanyisa ati toyina mateeka gojja muyitamu toyina parliament gojja yita tolina court gojja yitamu buli kyokola kati gwoba omuyambako kulaga nti olaba ne opposition yabaddewo ne participating kyova ne ICC tugiroopedde emisango tegisobola kuyitamu lwa nsonga political ewaka bitambula bulungi olabe politics atambula wali bulinaku atambula era asirike naye Uganda empya waliwo abantu nze bisaga kuddamu kulaba batereddeko stream eno kulaba ebibeera mu parliament gwe mulamu omukulu kubalaga engeri abasajja gye bakolamu nti ba MP waffe tebalina amakulu tebalina ekibatuuzaayo just kuweza mikono gya legitimacy ya musajja mu mateeka nti ne bwayise etteeka buli kimu kiba kiyise mu mateeka amatuufu.
So as clauses 8, 10 and 12 and 20
have you realized nti honorable bamuganye n'okumalayo byayogera babimuganye? That is it. Yabadde akimanyi nti era tosobola kukola bye batayagala naye ate era n'agendayo. Why? To help them to legitimize their thing. That is it. Museveni waba yagala oyise etteeka nga lyakutta ajja kututta tumalewo nga abasajja mwebali gye bakoma okubeeramu kiyambirako ddala kati olabono kati
Satura number 3 Satura definition in respect of foreigner and agent of foreigner which cross refer to clause 2 which in itself raises
Wilfred, that we will discuss that at committee stage. I will allow you to bring your issues.
Number 4, Right Honorable Speaker, is on criminalization of free speech. Number 5, and most importantly, Madam Speaker, this particular bill tends to infringe Article 1 of the Constitution by 1, trying to invert the sovereignty of the people into the sovereignty of the state. Article 1 of the Constitution refers to the people of Uganda being sovereign. What the state has is the authority to administer. So the title of the bill itself tells the lie about itself. And when you go through the bill, Right Honorable Speaker, apart from clause 5, which talks about the sovereignty of the people of Uganda, the rest of the clauses are in respect of the sovereignty of the state.
Okay.
And when we go to committee stage, Madam Right Honorable Speaker,
so we
have many amendments to make.
No problem.
Since we were never given an opportunity in the committee stage,
thank you.
We have amendments to make on almost all clauses in the bill.
Thank you.
May I invite my other colleagues who have minority reports to make their presentations?
Members.
Thank you.
Madam Speaker, I have something to tell you. Madam Speaker, in my capacity as the Shadow Minister for Internal Affairs, I went to the committee with a request to make a presentation. Madam Speaker, I happened to arrive before the Attorney General. The chairman of the day, Honorable Baka, requested me to wait for the Attorney General to present so that I could also be given time. After the Attorney General had made his presentation of amendments, Honorable Baka ruled that I will make my presentation while at Munyonyo. When we reached Munyonyo, Madam Speaker, Honorable Kajenje ruled that my request had been overtaken by events. Madam Speaker, I chose to write a minority report because the issues I was going to raise had not been raised by anybody else. So I wrote a minority report, Madam Speaker. Madam Speaker, you are now ruling that there is no time. Madam Speaker, as a member of the committee, I'm not supposed to debate. Madam Speaker, there was a memorandum that came from Uganda Kingdom. Madam Speaker, when we reached Munyonyo, the memorandum went missing. Madam Speaker,
You have said your stories now.
they have told you here. Let me tell the Speaker. Madam Speaker,
Honourable members, give Betty time. Some order.
Madam Speaker, I've heard the chairman telling you that when we were at Munyonyo, we heard from the governor, Bank of Uganda. And you know, Madam Speaker, I was so surprised because while the rest of us were in Munyonyo, we were never informed that even the governor of Bank of Uganda had gotten back to us. Madam Speaker, because of those many issues, we are also told that 700 people sent memorandums to the committee, but only 47 of them were accounted for. I feel so silenced. Is it your ruling that the people from Mukono should not be heard on this?
Honorable Betty. Honorable Betty, my sister. The people of Mukono have been heard. You've spoken for over 5 minutes. You've raised your issues, and we are going to address all of those issues. Honorable members, we have all these supplementaries, and not supplementary, but minorities. We are going to go committee by committee. And all of you are saying you have issues on each clause. Why don't we look at clause by clause? Honorable Odur has raised pertinent issues. Let's look at.
Madam Speaker, let the record be clear.
Honorable,
you denied me opportunity to present. Don't use my name. Don't
Honorable,
no, don't.
Honorable Dul, you took all the 35 minutes. Honorable. Honorable Lanya.
Right, Honorable. dissent. Right, Honourable Speaker, the minority, following Rule of Procedure 105 of Parliament, Right, Honourable Speaker, the bill establishes an extensive regulatory and criminal framework governing individuals and entities classified as agents of foreigners, imposing control and funding policies, policy engagement, and civic participations. The minority observes the several provisions, raise several concerns, including the vagueness and inconsistency of definitions, an extreme and disproportionate penalty regime, infringements on freedom of expression and civic space, duplication of existing legal framework, and the absence of commencement and the transitional provisions and duplications of the existing legal framework. Right, Honourable Speaker, when the committee engaged with many entities, you recall we engaged with about 53 entities. Out of the 53 entities, 52 were in support of this bill. 51, including Bank of Uganda, religious leaders, among others, were telling Ugandans that this bill, when passed, it will create economic instability in Uganda. That was the word from the governor of Bank of Uganda. Right, Honourable Speaker, this bill, it creates extreme and disproportionate penalty regime. The bill establishes a uniform and severe penalty structures, imposing custodial sex sentences of up to 20 years in prisons across wide range of offenses. Notably, the same maximum penalty applies to promotion of interest of foreigner. If you look at clause 5. Right, Honourable Speaker, participation in activities deemed to promote foreign policy. That is in clause 10. Publication of information characterized
Gilbert,
as
we have
economic
now
supplement.
gone. We have gone to closes.
Thank you, Right, Honourable Speaker. Right, Honourable Speaker, because of time, let me go straight to the recommendation. Right, Honourable Speaker, this minority came out with the following recommendations. Having engaged and got many views from Ugandans, the minority recommends that the House does not pass the bill in its present form. 2, the bill be withdrawn and remitted for comprehensive redrafting. 3, a revised bill should provide clear and precise definitions, established a proportionate penalty regime, aligned with existing legal frameworks, be supported by a credible economic and fiscal analysis, and finally, be subjected to broad stakeholders' consultation. Right, Honourable Speaker, the view of the minority is that the bill should be withdrawn. I beg to move.
Honourable Betty. Betty, 5 minutes.
Thank you, Right Honourable Speaker. Right Honourable Speaker, the points of my dissent are as follows. 1, Right Honourable Speaker.
Switch on. Switch on.
Right Honorable Speaker, it is my opinion that there hasn't been enough public hearing accorded to this bill. Right Honorable Speaker, you have been told that 57 memorandums were reviewed. But the fact of the matter, Right Honorable Speaker, is that the committee received over 700 memorandums. One of them, Right Honorable Speaker, as I've put it, being from the Uganda Kingdom. Right Honorable Speaker, when we went to Munyonyo, we are given time to go and study these memorandums on WhatsApps, but when we returned to the committee, Right Honorable Speaker, the committee did not give us time to make a presentation, as I've told you before. Right Honorable Speaker, it's not about allowing people to come to the committee. The purpose of the people coming to the committee is to give their opinion space that the people should be heard. But we are handling, my point of dissent is that the committee ruled in favor of only 2 people out of the 700 who opposed the bill, Right Honorable Speaker. Right Honorable Speaker, we are here fidgeting with time. This is not legislation. The committee is always given up to 245 days according to our rule of procedure 135.
Not 200.
45 days.
But if you get a committee which is efficient like yours, it can even do it.
It wasn't efficient, Madam Speaker. Even the problem of time can even be seen while we are here, Right Honorable Speaker. Right Honorable Speaker, my request is that the 11th Parliament stops behaving as if it is the last Parliament Uganda will ever have. There will be other parliaments that will come after this Parliament, Right Honorable Speaker. And Right Honorable Speaker, we are so honored that you will also be in that next Parliament, Right Honorable Speaker.
No, I can.
My recommendation, Right Honorable Speaker.
I can choose not to be because I have.
You already there because we have been talking to Mau.
How has Mao come here? Order. There's an order here. There is an order.
Right Honorable Speaker. Right Honorable Speaker, we are discussing a very important bill. And I'm wondering how Honorable Member is talking about their discussion out of this House. Is it in order to bring the name of somebody on sovereignty bill that we are discussing? Is it really in order?
Do you want to tell us that he's an agent of foreigners? No, the person they mentioned the name. Yes.
Right Honorable Speaker.
Betty, finish.
Right Honorable Speaker, the other point of dissent is on the issue of interpretation, Right Honorable Speaker. The law refers to the interest of Uganda. However, when you go into the interpretation, the interest of Uganda has not been defined. It also talks about the interest of the foreigner, which is also undefined. It also talks about government policy.
That is on the interpretation clause.
On interpretation, Right Honorable
Speaker. So you will
Speaker.
bring your idea when we are in that clause.
I thought, Right Honorable Speaker, you had allowed me to present my report.
No, what I'm saying, we will expect your idea on that clause, what you think, the amendment you want.
Madam Speaker, first of all, I'm a member of the committee who is not supposed to contribute to debate.
No.
Two, Right Honorable Speaker, you gave me an opportunity to make a presentation.
Honorable
and
Betty,
I was so thankful that
Honorable
you gave me
Betty, I am only advising you that when we reach that clause, I will still give you chance to bring in. So you read your report, but I will still give you chance to bring your proposal.
My recommendation, right,
Are we
Honorable
speaking
Speaker.
the same English?
Madam Speaker, I'm reading the report and you are giving me advice. I take your advice, Madam Speaker, but I continue to read my report.
You read. Yes.
I seek for your protection.
You finish. You continue with the report.
wakirinkubira mama kizigo oyo at least
Continue.
gasiya
I seek for your protection.
Members. Yes, there is an order from WOPA. Order
Thank
from
you.
WOPA.
order kyonna kyonna kyanguwa order leka babasabule.
I want to request, Right Honorable Speaker, there is a lot of noise, and yet the microphones that they are using is not as loud. So, the point of order that I'm raising is that, is it in order for members to make noise when a member is submitting? Is it it's okay to laugh, but let us laugh and allow the member to read her report? We now can't hear what she's actually reading. So, Madam Speaker, is it in order for members to continue shouting when a member is actually reading her report?
You are the one who was shouting. Honorable Betty, can you? Let's hear Honorable Betty.
on speaker.
All members, can we listen to Honorable Betty?
nze kyo kiparliament saa kibeeramu bannange kyoba ne president yabakuba
It is
bikonde
on.
kyoba president bwe yali
Switch on.
oyinza ovaako.
Thank you, Right Honorable Speaker. I don't know why this particular microphone is low.
Please go ahead. At least I can hear you.
Right Honorable Speaker, my suggestion, my recommendation is that this bill is withdrawn by the movers to give Ugandans time to make meaningful contribution to the debate and to accord Parliament enough time to handle a bill of this nature. Right Honorable Speaker, the Commonwealth practice is that parliaments which are about to retire don't handle controversial business. It's a practice, Right Honorable Speaker, and we are part of the Commonwealth, Right Honorable Speaker. The fact of the matter, Right Honorable Speaker, why that is required.
Which page are you in?
I'm reading page 3, Madam Speaker.
I'm not, and I'm following your report.
Madam Speaker, I move that this House finds that this bill violates the Constitution, rules of procedure, and the Parliamentary Convention, and that this House declares that the denial of the main report offends Rule 245 and 215.
214 and 215.
214 and 215. That it also declares that clause 2, 3, 5, 8, 11, 12, 24, 25, 30 are void for vagueness and the unlawful delegation of powers. That this Parliament rejects the joint committee report by the majority. I therefore also recommend that the movers of the bill withdraw the bill under Rule 141, defer the subject to the 12th Parliament with proper consultation.
An adventure. I love media tuned.
Article 1, define all key terms.
First of all, Rule 141 is on procedure of select.
141. Rule 140.
Sub-rule 1.
Sub-rule 1. That directs that any future bill must affirm that the sovereignty belongs to the people under Article 1, and that key terms in the bill are properly defined, that is, the interest of government, the government policy, what constitutes the actions that make one an agent of a foreigner, and that the minister is not given powers to alter the offenses under the bill as it is in the bill, the law as it is in the bill. Madam Speaker, in conclusion, it is my prayer that the protection of the Sovereignty Bill 2026 fails the test of the constitutionality, legality, and procedure. The 11th Parliamentary Final Act should be to affirm the supremacy of Constitution, not to legislate excessively. I so pray.
Thank you. Thank you. Yes, there is procedure matter from
Right Honorable Speaker, I want to thank you for the opportunity that you have given to those with the minority reports to present. It is in the interest of this country that all the voices of Ugandans are heard in this House. And those who have spoken represent those voices. Right Honorable Speaker, Honorable Jonathan Odur did say he wanted to make a presentation in the Munyonyo, but he didn't have enough time. Or he was not given the opportunity. And now that he has very many issues that he would love to present, together with the rest of his colleagues, and those who may feel there are procedural matters that were not handled well, but now we have the opportunity to look at this bill in a proper detail, provision by provision. I beg to move procedurally.
So what have you spoken?
I therefore want to...
I am asking, what have you spoken?
Kiwanuka. I'm raising a procedural matter.
Kiwanuka.
I was raising a procedure.
Kiwanuka. Honorable Kiwanuka, Honorable Kiwanuka, just raise the issues of dissent 5 minutes, like what Honorable Nwagaba did.
Thank you, Right Honorable Speaker. I have 7 points of dissent, and they are on page 2. Some of them have been highlighted briefly, but my approach was different. The point which has been left hanging is, Right Honorable Speaker, is starting from page 20. And that is where I am.
Let's have order.
Right Honorable Speaker, the minority have the opportunity to look at the amendments proposed by the committee, notwithstanding the matter in which those amendments were adopted during the meeting in Munyonyo. And I find that the amendments are excessive and affront to the past precedents of the House in regard to the amount of amendments allowed to bills. The minority are aware that the movers of the bill proposed additional amendments to their own bill, and the committee has adopted the same with additional amendments, resulting in an amendment totaling to 24 out of 30 clauses in the bill. That is 87% of the amendments in the bill were made. The nature and amount of amendments that are being proposed to this House are about 87%, and that is beyond the permissible amount of amendments that can be allowed. The minority wish to refer the House to the past ruling of the presiding officers of this very House on the amount of acceptable amendments to the bill, especially the precedent set during the consideration of the Public Service Pension Fund Bill 2022, as reported in the Hansard of 23rd May 2023. On that day, Right Honorable Speaker, the Deputy Speaker then directed the withdrawal of the Public Service Pension Fund Bill 2022 due to the amendments which were over 60% of the bill, and noted as follows. Right Honorable Speaker, I have studied various precedents, including the Hansard of 19 February 2019, where the presiding officer then, Right Honorable Jacob Olanya, guided on the magnitude of proposals for amendments to a bill. In reference to the Sexual Offences Bill 2019, which had been substantially amended, the Right Honorable Jacob Olanya guided as follows. Any amendments to this magnitude would require the minister to withdraw the bill and incorporate the proposals in the bill and reintroduce it for first reading again. In view of the fact that there are numerous proposed amendments to the Public Service Pension Bill 2023, I guide that if the minister agrees with the majority of these amendments, then the minister should move under Rule 140 of the Rules of Procedure of Parliament to withdraw the bill, incorporate the proposed amendments, and have the bill reintroduced for the first reading. The Attorney General can act on behalf of the minister on such a matter. If he agrees with such, so that they withdraw the bill, go and incorporate the proposed changes, gazette it, bring it for first reading, and reintroduce it to the public for consultation. I have read it and noted that there are very critical amendments made in regard to this bill. The rationale for the above directive, Right Honorable Speaker, was to shield the bill from being amended in a manner that substantially affects the subject matter of the bill. The minority wish to note that the amendments proposed to the bill go to the root of the subject matter of the bill, and the minister should be asked to withdraw the bill, study the bill and the amendments, and if agreeable, amend the bill and reintroduce it in the House. The withdrawal of the bill also affords government to benefit from the views of the stakeholders, both in support and against the report of the minority. Indeed, the Right Honorable Deputy Speaker, while directing for the withdrawal of the Public Service Pension Funds Bill, noted that therefore, once we allow the minister, they will go back and incorporate both issues in the minority report and those in the majority report, and you again subject them to the public. The biggest legislators are members of the public because we take their views and incorporate them into the clauses. In light of the above, Right Honorable Speaker, in light of the above ruling, the minority calls upon the presiding officer to comply with the earlier precedents of the House, which by virtue of Rule 8.2 I'm winding up, honorable members.
So, wind up.
Thank you, Honorable Speaker. In light of the above, the minority calls upon the presiding officer to comply with the earlier precedents of the House, which by virtue of Rule 8.2 of the Rules of Procedure of Parliament, which directs that the Speaker's ruling form part of the Rules of Procedure of Parliament until such a time when substantive amendments to these rules
Honorable, I don't want you to misquote the ruling of the former Deputy Speaker then. The former Deputy Speaker said, he quoted Rule 135.2, which says the committee shall examine the bill in detail and make all such inquiries in relation to the bill as the committee considers expedient or necessary to report to the House within 45 days, working days from the date of the bill is referred. The alteration is in regard to the object of the bill. I asked the first question, do we have an alteration on the object of the bill? And the question was no. And what right Honorable Jacob Olanya, rest in peace, meant was an alteration in the objective. which is the law. You can conclude.
Thank you, Right Honourable Speaker. I'll invite the honourable colleagues to have a chance and look for that record as well. Not me to mislead you as in one way or the other. Right Honourable Speaker, as I'm winding up, of course, the issue that the bill was rejected by the President and the majority of the stakeholders, that has been highlighted. The President of the Republic of Uganda, in the letter he wrote.
Which letter? Does the President just write to the public, or he's supposed to write to Parliament? Because it's Parliament who is holding the bill.
Honourable Speaker, the President wrote to the Bazukulu. And
I believe Musukulu.
Yes. The minority, Right Honourable Speaker, as I'm concluding, let me conclude, honourable members. Let me conclude in just 2 minutes. Just 2 minutes. The minority notes that 224 stakeholders the committee interacted with, only 2 stakeholders, being Asimwe John, the resident of Fort Portal, and the Honourable from Mawokota, Honourable Nsibambi, supported the bill. In addition, the minority also notes that His Excellency the President gave directives in his letter over his, which was posted on X, in respect of this matter. And I call upon, in my final statement, I call upon this House, this House, and I recommend as follows. The Protection of Sovereignty Bill 2026 that was read for the first time and referred to the Joint Committee on Wednesday 15th be rejected for the reasons listed above. Among others, I have only read one, but there are 6. Others which have been left behind. The report is very clear, uploaded. The Protection of Sovereignty Bill be withdrawn since it serves no purpose. The government is encouraged to consider providing remedies for matters affecting real societies, and the government undertakes to take practical steps to protect the sovereignty of the people from direct and indirect attacks to the sovereignty. And finally, Right Honourable Speaker, the rules of procedure be amended to ensure that no legislation can be proposed by the President or processed by Parliament after the general elections. Thank you, Right Honourable Speaker.
You mean after the general election you cease to be MPs? This country does not stop there. Procedure.
Thank you, Right Honourable Speaker. Right Honourable Speaker, this Parliament considers all our kingdoms very important, and they are great partners when it comes to making our laws when they present their views. In the presentation of the minority report by our honourable colleague Namboze, she mentioned twice that the views of Buganda Kingdom got lost.
I have not opened the debate yet. First wait.
I was just saying.
First wait.
No, we wanted to be withdrawn from the Hansard. It is bad. Yes, we wanted to be withdrawn.
Honorable Daddy, you have only 2 minutes.
Right Honourable Speaker, in the law that I studied, in that I taught some people, some of whom are in this house, there is room for accepting under protest. I want to accept some of your directions because you are the Speaker, but under protest. Number 1 is lumping me up with people I have opted to disagree with, and therefore saying all of you minority, you are lumped up together and you are given the same time. That's number one. Number two, that even where you, Right Honorable Speaker, and with immense respect, do not contain your members. You allow them to present for more than the time you had originally apportioned for all of us. Then when I come, you say 2 minutes. I know that in my wisdom, collected by age, among other things, I am able to present this in those 2 minutes or 5. But I also know that the country will not benefit. With that said, Right Honorable Speaker, let me thank my colleagues that have presented before, both majority and minority. Let me also associate with the bulk of the minority presentations to avoid repetitions. Why I opted to disagree with some of them, including the minority, is that I did not read any amendment purportedly presented by the Honorable Attorney General. My construction and understanding of the presentation by the Attorney General, I read it, I know he skillfully wrote in small words views of the Honorable Attorney General, and then in big letters on the Sovereignty Protection Bill. But I treat them not as an amendment. However, I treat them as views of a stakeholder. Yes. Reasons or points of dissent. I have summarized at page 1 the reasons for my dissent. Insufficient consultation on the bill by government and the committee. The bill inverts the constitutional concept of sovereignty in favor of the state in contravention of Article 1. The bill is accompanied with an incurably defective certificate of financial implication. The bill infringes various principles and articles of the Constitution. The bill does not cure any mischief and is therefore misconceived. The bill is redundant as there exists sufficient legal framework to cure any mischief. At page 2, Right Honorable Speaker and colleagues, 3.1 on insufficient consultation by the government and the committee, I have stated what you're able to read, but with emphasis on Article 1. I also emphasize that the consultations were conducted here and we've never moved anywhere outside Parliament, as if the rest of Ugandans have no views to contribute on such an important subject. Sadly, influencing government policy is sought to be criminalized in this bill. See clause 7.4 of the bill. Right Honorable Speaker and colleagues, at page 4, I traverse the reasons that I have given, and I cite the case of Malema Biris and others versus Attorney General, Constitutional Petition number 2 of 2018, and the decision of court to the effect, in summary, that consultation is not cosmetic, but goes to the root of our constitutional governance. In 3.2, that the bill inverts constitutional concept of sovereignty in favor of the state and contraventions of Article 1 of the Constitution, I associate with the elaborated submissions of my colleagues to avoid wasting time and eating much into my 2 minutes. 3.3, Madam Speaker and colleagues, the bill does not cure any mischief and is therefore misconceived. And the summary of this, one is that there exists sufficient legal framework. But if you look at page 6 of my submission, it is sought or to be understood that interference with the development and implementation of government policies and programs, which interference is funded by foreigners and agents, is the mischief. That foreign aid to civil society that comes along with conditions and parallel programs which conflict with government programs, this has given external donors, I understand, significant influence over the Uganda's political, social, and economic landscape, which has resulted into erosion of our values. C, that the use of online platforms by foreigners and agents of foreigners to disseminate information facilitates social discord. The minority, and that is me now because it is a single man's minority report, note that the bill is misconceived since it is based on the wrong premise, that Uganda has no specific law upholding sovereignty of the country, which has resulted into continuous interference in the government's policies and programs by foreign countries and agents of foreigners. That no laws exist on the book to regulate activities of civil society, and that the law regulates the use of online platforms. I note that 1, the Constitution only guarantees sovereignty of the people as against the state. No wonder the laws of Uganda are silent on this matter. There exist laws which include, among others, the NGO Act, the Man Laundering Act, and the Penal Code, which are sufficient to guarantee our security and sovereignty. In addition, I note that the bill further is misconceived because it restricts funds procured from abroad, thereby indirectly affecting the operations of financial institutions and the Bank of Uganda. Let me note that the majority report was uploaded yesterday at 4, so this one is taken care of. And for that matter, I will proceed to the next. It creates a regulatory arbitrage by extending the bill to persons and institutions already regulated by other acts of parliament. For emphasis, honorable colleagues, each and every sector we are talking about is regulated, including the political sector, which is so to be the target of this. And you are able to read for yourselves A up to K at page 9. Right, Honorable Speaker and colleagues, although the bill seeks to safeguard the sovereignty of Uganda from external influence, it grants agents of foreigners, once registered, the right to interfere with sovereignty. For instance, an agent of a foreigner who registers with a minister can implement government policy or government services under Clause 6, strangely, can influence development of policy under Clause 7, can implement government policy under Clause 8, can interfere with the electoral process under Clause 11, simply because of registration. All the activities that are allowed for an agent of a foreigner under the bill will affront Article 1 of the Constitution, whichever way you look at it, even when the minister allows. It is an affront. And the bill assumes that what is offensive to the Constitution becomes lawful simply by allowing it under an act of parliament, insofar as they will infringe the sovereignty of the citizens of Uganda by subjecting it to the influence of foreigners. The so-called acts allowed under the proposed law will still be offensive by their nature, being an affront to sovereignty. The minority note, therefore, that had the bill been conceptualized properly, indeed by being overly vague and ambiguous in relation to its application and the activities it seeks to regulate, it may be declared void for vagueness and the stretching beyond the parameters of the Constitution. At page 9, the bill infringes several articles. My colleagues have mentioned quite a number, specifically Article 1. I also opine that it offends Article 259 to the extent that it seeks to amend the Constitution by infection. This was canvassed in Paul Semogere Zakalo Luma and Juliet Reina Kafire versus Attorney General, Constitutional Appeal number 1 of 2002, in which the Supreme Court declared Section 5 of the Constitutional Amendment Act 2000 as unconstitutional since it had the effect of amending Article 28, Article 41(1), and Article 44(c). Right Honorable Speaker, in that case, it was declared unconstitutional for having been passed without following the procedure under Chapter 8 of our Constitution. Court also discussed the effect of Section 5 of the Constitutional Amendment Act, which proposed to introduce new clauses 2 and 3 of Article 97 with the intention of restricting citizens' unhampered access to information in the possession of the state. You may read for yourselves, and I'll proceed to page 12. The bill infringes on the following articles of the Constitution, making it grossly unconstitutional in form and effect. Number 1, unconstitutional deprivation of citizenship. Right Honorable Speaker, citizenship is not granted by statute. By seeking to reintroduce the foreign element against Ugandans, the bill offends Articles 9, 10, 11, 12, 13, 14, and 15 of the Constitution. Freedom of expression under attack. Article 29, 1A and B, which provide that every person shall have the right to freedom of speech and expression, freedom of thought, conscience and belief. Now clauses 5, 7, 8, 9, 7, 8, 10, 12, and 13, and the definitions of disruptive activities in clause 1 directly criminalize expression and association including influencing the public to oppose the policy of government. Clause 2(2)(g), engaging or participating in a riot or unlawful demonstration or assembly. The definition of disruptive activities is offensive. And publishing information said to weaken the economic system. Clause 13. These restrictions are neither demonstrably justifiable in a free and democratic society as provided for under Article 43(2)(c), which provides that public interest shall not permit any limitation of the enjoyment of the right and freedoms prescribed under the Constitution beyond what is acceptable and demonstrably justifiable in a free and democratic society. 3. Freedom of association and assembly threatened. Right Honorable Speaker and colleagues, Article 38(2) of the Constitution guarantees every citizen's right to participate in peaceful activities to influence the policies through civic organization. Now listen to this. Clause 7(3), Clause 8(3), Clause 8(4), and 12 substantially burden and in some places extinguish that right by criminalizing conduct that constitutes its core exercise. 4. Right of equality invaded. Under Article 21(1), all persons are equal. Now, when it comes to the definition of foreigner, a Ugandan citizen residing outside, that has been sorted, and I accede to that. Then the foreigners in their own country, and converts persons into those who deal with them. Intrusion of privacy, where the minister, the right to privacy of a person and property, and no person is subjected to unlawful search or unlawful entry into the premises. Clause 28 confers the person appointed by the minister to inspect the premises on an agent of a foreigner. Void for vagueness. I think the Honorable Betty Namboze has hinted on it, on the wide and arbitrary provision. Authorities to look at are Andrew Kalamaji versus Attorney General, Constitutional Petition number 5 of 2016, which struck down Section 25 of the Computer Misuse Act, Charles Onyango and another versus Attorney General, Constitutional Appeal number 2. The bill departs from the legality principle under Article 28. Interests of Uganda, I think Honorable Namboze has hinted on it, they are not defined. Agent of a foreigner, Clause 1. The definition is extraordinarily broad and captures any person who acts at the order, requests, under the direction, and control. I have specifically highlighted the threats that I consider legitimate in those bullet points at page 14. Now, the foreigner clause, I think, has also been canvassed together with the disruptive activities and economic sabotage. At page 16, Right Honorable Speaker, I have highlighted the threat against the freedom from cruel, inhuman, and degrading treatment and the attendant authorities. The bill is accompanied with a defective certificate that has been canvassed by the Honorable Odul Jonathan, and I want to associate with him, but point out or be specific on the following areas. One, that the estimates of revenue and expenditure over the period of not less than 2 years after the coming into effect of the bill, when passed, the impact of the bill on the economy are not canvassed in the certificate. The certificate simply laid down the principle of what we may achieve in broad terms without telling us what we are likely to spend on implementing and whether government is prepared to spend that money. To that extent, the certificate is incurably defective and cannot support this bill. The bill has also the potential to destabilize Uganda's balance of payments. I think reference has been made to the submissions of the Governor Bank of Uganda, and I associate in the same terms. The financial sector and de-risking the operational paralysis, the capital requirements and the funding gap, the policy framework inconsistency and the voluntary shocks have all been canvassed. And then the second last is the amendments proposed by the committee, good as they sound, are equally excessive and disregard the precedents of the House. They also disregard the procedure that ought to have been adopted as elaborated by my colleagues earlier. Finally, Right Honourable Speaker, for my reasons, this is where I'm going to refer to the letter written by my brother, the President. And here nobody will ask me whether he wrote it or not, because having said he's my brother, I think I know him better than anyone. The bill was rejected by the President and majority of the stakeholders in the committee that the committee engaged with. Right Honourable Speaker, the statistics have been given. Of all the persons that appeared, I think only 3 people supported, 3 stakeholders. The Honourable Yusuf Nsibambi, the Honourable Chiriowa Chiwanuka Attorney General, I treat him as a stakeholder because he was not the mover, and the gentleman from Fort Portal, Mr. Asimwe, that has been referred to. The President himself did state that this is not the bill that he initiated in Cabinet. But it does not stop there. Even General Severino Kahindo Tafile, who was stated to be the mover of the bill, evaded the committee proceedings, yet is the one who must have received the President's instructions, only to be misconstrued with immense respect by my son, General David Muhoozi, who appeared, and not the minister.
Honorable David Muhoozi is a son-in-law, because he marries from him.
Yes, he's my son. In Africa, we don't say that. He's my son. So, Right Honourable Speaker, the general conclusion is that the minority, and that is me now, wish to remind colleagues that Uganda is here to stay. And therefore, there is no need for firefighting. The country must not be stampeded into criminalizing politics, because politics seems to be left as the only target in the name and behind the curtain of sovereignty and security. The existing laws were not enacted in vain. They must be allowed to serve their purpose. The bill as proposed is inimical to democratic tenets, constitutional commands, and injurious to good conscience, which principles we must be jealously guarded and protected with utmost tenacity by all Ugandans of goodwill. The minority therefore recommend as follows. 1, the Protection of Sovereignty Bill 2026 that was read for the first time and referred to the Joint Committee on Wednesday, 15th April 2026, be rejected in its entirety for the reasons stated above. that the government undertakes to take practical steps to protect the sovereignty of the people from direct and indirect attacks, including by those claiming to fight for us. Medad Lubega Segona, MB Usiro East. I thank you.
Thank you, Honorable Medad, for that report. The opposition, yes, motion. Is a motion.
Right Honorable Speaker and honorable colleagues, having heard from the substance of the majority report and the substance of the minority reports, I rise pursuant to Rule 17, Sub-Rule 1 of our Rules of Procedure, which states, a member may, with the consent of the Speaker, move that a rule be suspended in its application to a particular motion before the House. I therefore move, Right Honorable Speaker, that the application of Rule 214, Sub-Rule 14, and 214, Sub-Rule 15, be suspended to waive the requirement of a 3-day period between the presentation of a report on the bill and the debate. I beg to move.
Seconded. Okwalinga, Namiliango, Echweru, Balamu, Odoi, Kabanda, Honorable Acheni, Silas, Charity, Nekesa, Rakajara, Lanyo, Abe, Akelo, General, Esther, Sanoni, Apoloto, Abeja, Ibanda, Omara, Chut, Water, Mariamu, Eric, Gabriel, Toroma, Amuria, Phyllis, Nyakato, my brother from Bugisu, Maxi, by the whole side, and 3/4 of the other side, the vice president, the prime minister, the government chief whip, Honorable Yusuf Sibambe, the yellow boy, and then Mama Wabana, yellow girl, and then the Honorable Businje, Honorable all the elders and all the disabilities. Honorable Nabakova is also there. Just fine.
Right Honorable Speaker, the justification of my motion are basically in threefold. One is that Rule 214 and Rule 215 are not falling under the confines of rules under Rule 17, Sub-Rule 4 that are entrenched, implying literally the two rules can be suspended. Reason number two is that this particular report on the bill was uploaded on our parliamentary information system. Members here present have perused through the report, and I believe with the turn-up you have in the House, we are ready to proceed just like we have proceeded with the main report and the minority reports. Reason number three is that the members who are required to discuss and debate this report as presented are here present and gathered in big numbers. Basing on the three reasons, I justify that my motion for suspension of the rule, if it pleases you, do carry the day. I beg to move, Right Honorable Speaker.
Thank you so much. Wilfred?
Right Honorable Speaker, I do strongly oppose the motion to suspend the rules on account of 3 grounds. One, it is apparently clear that the speed at which this bill has been moved, majority of the members are yet to access the records, the minutes of the committee meetings, and even the reports for them to internalize and appreciate the essence of this particular bill. Two,
how many members have reported to you that they have not had access to the information?
Right Honorable Speaker, speaking as the alternative Attorney General, we had 6 minority reports. Of course, you know the presentation has not been to its logical conclusion, and the majority of the people have remained seated here who did not stand up to support the motion, have not had time to look at the reports, read them, internalize, and even the minutes. Incidentally, even the minutes of the committee were not read by the mover of the motion.
They are there.
So 3, most importantly, Right Honorable Speaker, this particular bill touches fundamental rights of the people of Uganda, both within and without the territorial jurisdiction of this country. So it is important that members be given time to debate the reports. Those who do not intend to debate can, yes, keep quiet, but give members opportunity to debate. So I do strongly oppose the motion to suspend the rules on debate of this particular important matter.
Attorney General.
Right Honorable Speaker, I think the question has been put more to the members because
I only want you to respond to what the shadow has said.
Yes, the honorable member seems to doubt the members' capacity to read quickly, which I strongly oppose, because I think these members have the capacity to read and understand these things. So it's not, of course, this law is not about Ugandan, it's about agents of foreigners. So I think, Right Honorable, the question should be put to the members to decide whether they are ready to deal with the issues in the bill or not. I beg to submit.
Honorable members, I put a question that Rule 2014, Sub-Rule 14 and 15 be suspended to enable the House to deliberate upon the report of the Committee of Protection of Sovereignty Bill without having to wait for the 3 days as per the rules. Those in favor say on the contrary, nay. The ayes have it. The ayes have it.
Right, Honorable Speaker.
Can you sit?
Honorable Speaker, the rules allow them to stand, and I wanted to quote for you the rule. Right, Honorable Speaker. Rule 107 of our rules of procedure provides for division. 1B. So a division may be ordered by the Speaker or Chairperson where B, the Speaker has announced the results of the voice voting, and immediately 40 or more members stand in their places, signifying their disapproval of the outcome of the vote. Honorable Speaker, from what we had, the noes had it. But you announced that the ayes have it. So these are more than 40 members who are standing up to say, put this to a division so that we count per head. It is the rules of procedure. Some of you don't read the rules. You need to start reading the rules. So, Madam Speaker, the rules allow for voting by division when 40 members stand up. These here are more than 40 members. So I would like to implore you that we
do the casting by division so that we ascertain. Because as it stands now, we don't believe the announcement you made, Right Honourable Speaker.
Honourable members, I will not speak before you sit.
Madam Speaker, you have to kindly rule on the 40 members standing up.
Okay, you sit.
Right Honourable Speaker, the rule says you've got to first ascertain that these are 40 plus.
Honourable members, I don't need to ascertain. Even if you're 50, I am going to allow division. I am going to allow it, and then we see. And one thing I can tell you, whether we do what tactics of delay, we shall finish. Honourable members, Lope appoint a teller for the nays, and then Honourable Bua appoint for ayes. The ayes can move this side, and the nays move this side. Yes. Go to the lobby. Go to the lobby, and yes. Ayes, but Majegere. And the ones abstaining can remain with me here.
Get updates on politics plus travel and lifestyle content, live streams, analysis, and adventures across the region. Subscribe, like, and drop your comment. APM Media TV. Stay tuned. Get updates on politics.